Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Well, as we know, since the 2020 Summer of Love, firearm sales have been going through the ceiling. In fact, the United States has sold more guns in the last 2.5 years than at any other time in our history. Many of those purchasers were first-time purchasers, but many of them were repeat customers. Now, in the same time, we've had a radical update in digital databases from the NICS system, and then a change in administrations where suddenly the ATF wants to do anything and everything within their power to disarm you, the lawful and responsible gun owner. To that end, we have beginning to see more and more denials happening on common background checks to purchase firearms, and many of those are unexplained. So today, we're going to have to spend a few minutes and talk about what happens in Washington State if you are denied a firearm purchase. Okay, so the issue we're talking about here is what happens under Washington State law if you go in, attempt to purchase a firearm, and you are denied that purchase. What sort of notifications go on between state agencies, and how much trouble might you actually be in? Now, let's back it up for a minute, because as you know, in this video right here, we talked about how there is a new federal funding that's going to require the ATF to notify local law enforcement agencies of all denials based upon the zip code of the would-be purchaser. And I mentioned in that video that that doesn't have a huge effect on us here in Washington State because we have a state statutory scheme that's already kind of in place. Now, interestingly, that state scheme is supposed to change. It was actually supposed to change 2 years ago, more than 2 years ago, and we'll talk about why that has not changed, because there's a new law that has a contingent effective date but has never been enacted because the contingency, well, that hasn't been met. So, every FFL in Washington State, if a person goes in, fills out their form 4473, submits to a background check to get a firearm, if that check comes back as denied, there is a denial of the purchase for whatever reason, then RCW 9.41.114 kicks in and creates several mandatory duties that every single FFL must comply with. That law, which looks a little bit like this, starts off by saying, a dealer shall report to the Washington Association of Sheriffs and Police Chiefs information on each instance where the dealer denies an application for the purchase or transfer of a firearm, whether under RCW 9.41.090 or RCW 9.41.113, or the requirements of federal law as the result of a background check or completed and submitted firearm purchase or transfer application that indicates the applicant is ineligible to possess a firearm under state or federal law. So right there, the FFL is told, hey, listen, any denial for any reason, if it's because the person is ineligible, you have to report immediately to the Washington State Association of Sheriffs and Chiefs and Police. Now, the statute has more to it, though, of course, and the rest of it reads as follows. The dealer shall report the denied application information to the Washington Association of Sheriffs and Police Chiefs within 5 days of the denial in a format as prescribed by the Washington Association of Sheriffs and Police Chiefs. The reported information must include the identifying information of the applicant, the date of the application, and the denial of the application, and other information or documents as prescribed by the Washington Association of Sheriffs and Police Chiefs. And then the statute in subsection 1 finally further states, in any case where the purchase or transfer of a firearm is initially denied by the dealer as a result of a background check that indicates the applicant is ineligible to possess a firearm, but the purchase or transfer is subsequently approved, the dealer shall report the subsequent approval to the Washington Association of Sheriffs and Police Chiefs within 1 day of the approval. So, just so we're clear, if you are denied because you are ineligible, the FFL has to report that to state police within 5 days. If that denial is later changed to an approval for some reason, the FFL must notify authorities within 1 day. Now, What's different between this and the proposed federal thing? Well, it's really just the way we're reporting. Under the proposed federal law, what's going to happen is that the ATF is receiving additional funding, and when they get a denial, they have to report that to local law enforcement. In Washington State, the FFL has to report that to state law enforcement, and rest assured, state law enforcement then immediately turns around and reports that to local law enforcement. Now, if you go and look the statute up, RCW 9.41.114, the statute that looks like this, you will see down here that there actually is a proposed amended RCW 9.41.114 that was passed into law in 2020 but has a contingent enactment date. What is that contingent upon? Well, it's contingent upon the State Patrol getting their act together, because if you compare the current version of the law right here and what the proposed amended version of the law will look like here, you can see that what it does is it essentially takes away all of Section 1, all of the wordy stuff that we've talked about, and it leaves us only with the following section, which is still currently part of the good law, and ultimately someday, depending on whether the State Patrol actually puts together the correct background system that is required by law, this section will be the only section remaining in 114. Now, that section reads as follows. 2. Upon denying an application for purchase or transfer of a firearm as a result of a background check or completed and submitted firearm purchase or transfer application that indicates the applicant is ineligible to possess a firearm under state or federal law, the dealer shall A. provide the applicant with a copy of the notice form generated and distributed by the Washington State Patrol under RCW 43.43.823 sub 5, informing denied applicants of their right to appeal the denial, and B. retain the original records of the attempted purchase or transfer of a firearm for a period not less than 6 years. So if and ever RCW 9.41.114 is amended, what's going to happen at that point is, because the State Patrol will already be maintaining this system, they will be able to notify local law enforcement. The duty will now be taken away from the FFL and placed actually within inter-office communication, interdepartmental communication. The only thing that will remain, and what is still good law now, is, listen, when you are denied an application, you are entitled to have a notice as to the reason why and to have the grounds and the ability to appeal articulated to you. Now, the other big difference between this state law and what's being proposed or funded on the federal side is apparently ATF is also going to notify local law enforcement on the federal side anytime there is a delay. There is nothing in RCW 9.41.1114 that speaks at all to delays, and it places no onus on any FFL nor any law enforcement agency to do any notification upon a delay. And that's wise. Why? Well, because there are millions of delays occurring every month for no reason other than the system is breaking under its own weight. Listen, you may have more questions about what happens in the event of a denial, anything else related to a 4473, or anything else related to your Second Amendment rights. And if you do, don't ever hesitate to contact us at WashingtonGunLaw.com, or of course you can call us directly at 425-765-0487. Now, let's remember, part of being the lawful and responsible gun owner, like we talk about all the time here at Washington Gun Law, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching, and stay safe.